Florida court rules that punitive damages are available to victims of distracted driving car accidents. Under the state's distracted driving law, texting while operating a motor vehicle is a primary offense, which means police officers can pull over a driver solely for holding their phone while driving a car. If you or someone you love was hit by a driver who was texting while behind the wheel, you may be able to pursue money for damages, including medical expenses, pain and suffering, and the loss of income. But there is also another category of damages: punitive damages, which are awarded if your case meets specific criteria. Punitive damages are intended to punish the defendant and deter them from similar conduct in the future. Compensatory damages, on the other hand, aim to compensate the victim for their losses. However, punitive damages are almost never available to victims of car accidents, as they are only awarded if the defendant's actions amounted to intentional misconduct or gross negligence. Until now, the sole basis for these types of damages in car accident cases was drunk driving accidents. However, a recent case demonstrates that punitive damages may be available to victims of auto accidents involving distracted driving. Earlier this year, a Florida appellate court ruled that a driver's use of a cell phone while driving could serve as the basis for a claim for punitive damages following an auto accident. In the case, a trial judge allowed the victim to amend their complaint to include a claim for punitive damages against Publix, a trucking company, and its truck driver who used a hands-free cell phone during a collision. The crash happened after the trucker ran a red light, killing a pedestrian. That's when the plaintiff's attorney presented the following evidence to obtain punitive damages. Evidence showing that the truck driver was on his cell phone. Records demonstrating that the driver's employer specifically trains its drivers and prohibits distracted driving. Proof that Publix allows hands-free cell phone use. A copy of the Florida CDL handbook, which specifically states that hands-free cell phones can be just as distracting. The trucker's cell phone records showed that he had been on his phone most of the day when the truck accident occurred. After the trial, the appellate judges concluded that the truck driver's use of a cell phone supported a claim for punitive damages. So, when are punitive damages available in Florida? Well, Florida law imposes a limit on punitive damages. Typically, the cap is 3 times the compensatory damages or $500,000, whichever is greater. Speak with a knowledgeable Florida personal injury attorney to determine whether punitive damages are available in your particular case. You can schedule a consultation with our lawyers at the Turnbull firm by calling at 407-612-6464.